Welcome back to Defense News Weekly. I'm Diana Stancy. If you've got a phone and you're in the military, you've got TikTok. Every day, service members are lip-syncing, dancing, and emoting their way through their time in uniform, with a wide variety of results. But where does fun on social media potentially cross a line? One Navy officer recently found out when his video earned him a court-martial. The offending material? An homage to the Thank God It's Friday attitude right before you head out on leave via a profane rendition of Frozen's anthem, Let It Go. Check it out. Okay, maybe not the best idea for an officer, but did it really cross a legal line? Military Times managing editor Jeff Zuzulowitz stopped by earlier to talk about the story. Thanks so much for joining us, Jeff.
Hi, Diana. Thanks for having me.
Great. Well, walk us through this case. What exactly happened here, and why was this military officer court-martialed in the first place?
Sure. So back in the summer of 2023, a Navy lieutenant commander, that's the equivalent of an 04 in the service, recorded kind of what he took to be kind of a humorous TikTok video that he would later claim, was only intended for his family and closest friends. He kind of lip-synced a profanity-laced version of the song Let It Go from Frozen. And he was wearing his uniform at the time, and his, 04 oak leaf cluster was square in the frame. A few weeks later, his higher command out on the East Coast caught wind of this. They started looking into it, and later in 2023, a charge was referred against him for conduct unbecoming an officer and a gentleman. His private attorney argued that this in no way constituted conduct unbecoming, and a military judge at a court-martial earlier this summer found him not guilty.
Now, what do legal experts have to say about this case, and are they in agreement about how this was handled?
I spoke to 4 or 5 civilian defense attorneys, prior military folks who now defend troops, and they all question the command's decision to charge this officer in this case. They all pretty much agreed that this could have been handled by reading him the Riot Act, maybe some administrative actions, but they all felt that a federal conviction for an infraction like this was way out of bounds. And his civilian defense attorney argued as much during the trial, and the trial judge ultimately agreed with that argument.
Now, what are some of the key takeaways from this case overall, and what should other service members reflect on as they hear about this?
Think twice about what you post online, especially when you're in uniform. People did dumb stuff throughout human history, but now when you post it online, it's there forever.
Jeff, I know you talked to some legal experts on this matter. Let's take a look at one of those conversations.
We're joined now by Rachel VanLandingham. She's a professor of law at Southwestern Law School, a retired Air Force JAG, and a former president of the National Institute of Military Justice. She's here to break down this case and help us understand it further. Rachel, thanks for joining us.
Thank you so much for having me.
So you reviewed this case for us before we ran our story, and you and I discussed it at length. What stood out to you in general about this case, and how often are we seeing troops court-martialed or tried for social media, postings that they do either in or out of uniform? How common is this?
It's not common at all. And in fact, military criminal prosecutions themselves are increasingly less common. The numbers of courts-martial that have occurred over the last 15 years have been on a drastic decline, straight angle down. So they really are supposed to be reserved for serious misconduct, criminal misconduct, not penny ante, perhaps stupid lack of judgment action, but for real serious crimes. And so that's why this case really stood out.
What was your take on the decision to charge that and kind of how that whole case played out?
What I saw was the abuse and misuse of the criminal justice system that's designed to provide, it's really designed primarily, first and foremost, to deter misconduct by levying a pretty heavy penalty, a stiff penalty on someone. If someone is court-martialed and convicted within the military, either what's called a special court-martial or general court-martial, they have a federal criminal conviction for the rest of their lives and the collateral consequences that follow from that. So this is not just, oh, some administrative measure or something that stays within the military. This is something that can follow someone for years. Does it warrant some kind of disciplinary action by a commander? Sure, I think it did. But a federal criminal conviction? Are you kidding me? Are you kidding me? I mean, they don't bring many of the vast majority of sexual assault allegations against service members to court. They don't court-martial those. They court-martial a tiny, 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 tiny fraction of those. Yeah, you're going to court-martial this guy for blowing off steam off TikTok. It just, to me, demonstrated the lack of judgment commanders have regarding when to prosecute and when not to. They should not have any kind of prosecutorial discretion. Congress decided that commanders could not be trusted with disposing of sexual assault crimes. They cannot be trusted with murder. They cannot be trusted with manslaughter. If commanders can't be trusted with serious crimes, the disposition of serious crimes, why do we think they can be trusted with any crime? And I think this case really brings that up.
Rachel VanLandingham, thanks so much for joining us.
Thank you.